Hey guys, welcome. Hello, everybody in chat. I hope you had a good day. So I was bored at work a little bit today, and I was court hopping, and I found CRD court hopping as well. And I spoke to CRD a bit. And CRD has a hotel. The animals so far are fine. The husband's staying at home with the animals. CRD's in the hotel. They can bring the doggy to the hotel if it gets too hot. So they'll have no estimated time on when the electric will be back on. That sucks. That sucks. But we spoke to her. Fozzie kept us updated. Thank you, Fozzie, because we would have never known. Hi, Diana. Hi, Debbie. All right, I got a bunch of stuff today. So I have a mixture of, the little crazy ones and then the stress-inducing ones. Hi, Cha. So we're just going to go up and down. I broke them up. So we're doing a crazy one and then a stress-inducing one and then a crazy one to bring us back down again. And we're just going to flip-flop back and forth. And we're going to go across the pond. Because it was interesting. Hi, Gen X. So let's start with a crazy one. We're going to roller coaster this one, and this is a whole roller coaster. The audio is a little bit loud and bumpy to begin with, and then kind of evens out. But the lawyer is just loud, and she laughs really loud.
Right now too. Okay, Greg's probably got to print out a face sheet for Mr. Barabo.
I'm just gonna ask him to set him over. We're working on his ID stuff, but it's taking longer than most.
All right, I can pull the case up. Let's take a look at what we've got. We've got 2 cases. Greg's going to print out face sheets. But you're basically saying you'd just like us to continue it on?
Yeah, and if we could just move it to that 11th date next month, I think that would work.
Mr. Barabo, thank you for coming to court.
Thank you,
being timely. I appreciate you've been here a little bit of time, so I appreciate you being here.
I wasn't exactly timely. I was my normal oppositionally defiant late.
Sure, that's fantastic.
Did, however, a serious issue in town, somebody who means anything needs to address. 14 months ago, Jerry or Geraldo, the Western operator responsible for supervising trash pickup downtown and on the hill.
Western Disposal?
Yes. He got promoted to a roll-off truck simply because he was the last person qualified to be able to, we believe. Anyways, the people who have replaced him have a combative oppositional defiance disorder concerning putting dumpsters away with their lids facing forward and closed. They have destroyed 2/3 of the dumpsters. Literally the first day a new dumpster is out. I have learned from property management from 4-Star and several other lesser property managements. Western is charging double and triple charges for the violations that they are creating by destroying dumpsters and putting them inaccessible. This on top of the massive destruction they've done to people's cars, the buildings, leaving dumpsters in alleys.
Now, are you talking about dumpsters that are on private property?
No, public alleys.
So, but they're attached to a house or apartment or something like that. Okay. So it's not city property where the city has, I'm just trying to think of.
It becomes city property when they can't put the dumpster away and leave it blocking a public alley.
Right.
They don't seem to know that for decades across America, you've drawn lines down the telephone poles and you can't come over. That's what the lines are typically in alleys. And you're now encouraged many parking violations in addition to the trash violations.
So let me back you up and make sure I understand what you're saying. what are they doing with the dumpsters?
Damaging them by mishandling them with the truck, crushing their lids. By manufacture, they've dramatically changed the structure of the dumpster. It is nothing like the original, on record, certified, inspected, bear proof that is required. They're using residential door hinges in random directions, little tack welds. They break immediately.
I see. Okay.
They are putting the dumpsters 90 and 180 degrees wrong facing so the tenant can't even reach them.
I'm just trying to think of who I direct you to share this with.
I've shared it with police because code enforcement has told me repeatedly that some of this is police department issues. Code enforcement doesn't come out until 8. They, if they find any more violations, are writing up the violations usually of Western, spending between 5 and 8 o'clock damaging dumpsters and putting them away wrong.
Okay.
They are therefore alleging their violations against the property owners when it's Western doing this. So it's endemic across town now.
So our prosecutors are here and they're hearing the same conversation. They can probably forward the information along to...
I would like to hope so, because I've spoken to every responsible person in the Hill. From parking services to code enforcement to access and parking.
We probably have to figure out who the city's contact is with Western Disposal.
I would recommend do a 1-week surveillance run following the dumpster trucks and witnessing their poor behavior.
Surveillance.
As reference, I recommend Stephanie is maintenance, groundskeeping for 4-star, which is responsible for a lot of those properties.
Okay.
She bears witness and shared with me that they have an oppositional defiance disorder against her, telling them to put the dumpster back where you found it, how you found it. It's really simple. Our local bear is making waves in the news. People talk about shooting him.
Okay.
He's a really cool bear. He doesn't need to be shot.
Okay. All right.
These are some of the issues that I deal with on a daily basis.
All right. I'm going to return to your cases here. I'm going to put a note here. We're going to reset for the June 11th, 2024 at 9:30 on both of your cases.
Thank you very much.
You're welcome, Mr. Barabo.
My other large concern is that the quote from property management and maintenance is that they're using up all of their money paying these trash overcharges. I have been assaulted with dumpsters by Western operators for daring to close the lids in front of them. So now I have to...
If I had a nickel for every time I was assaulted by a dumpster, I would be rich.
To be frightened of Western operators and violent assault. So I have to avoid them while I follow them around the hill and pick up after them.
Well,
I have to avoid them while I follow them around. That's what he just said out loud.
Joke is old-fashioned immigrants used to dig under the fence. They had the strength too. These new modern immigrants must have bribed somebody to walk through the gates. Not even strong enough to handle a dumpster.
I'm not even going to comment on that one.
My bad. Okay. It is highly inappropriate.
Yes, it was.
That is the joke that I've made on this issue. They act very careless, and they seem to be acting out of a financial interest.
Okay, I just thought the guys needed to do with their immigrant status. So
yeah, well, my apologies on that. Only because I've been accused by their supervisor of being racist, because they will say, even to property management, no speak English, when they know for certain they do not hire anybody that doesn't have a working grasp of English.
Okay.
So they're playing them against.
Not this judge. Nope, not this judge. This judge will stick with it. Stick with it. I'm telling you, this judge will be so nice and stick with it.
The population and these politically incorrect racial stereotypes, making false accusations. This covers up their negligence and incompetence.
Okay.
It's not working.
All right.
Thank you, Your
All
Honor.
right, Mr.
My
Barrett.
apologies.
That's okay. We're gonna
I've
get
been
you.
trying to voice this for 14 months.
We're gonna get you the setting notices, so don't leave yet.
He's got him.
Oh, you got him?
Yeah,
Okay.
he's got him.
Great. Anything else from you, Mr. Lee, that we need to call?
I know.
Whew. You did. Wow, I just said something brilliant. You know, everybody says that when they're muted. They say, "Oh, wow, I just said something brilliant." So now we're gonna go to Florida, and I got this from Okaloosa Court TV. They're the ones that played that whole docket, the whole docket of the one courtroom, and I put the link in the description of the video. Yeah, the reason why I was muted is because I wanted to practice it first before I said it. And then I forgot what I said anyway. So we're mixing these up. We're mixing the Okaloosa to get us through the Battle Creek? No, not Battle Creek. It's Lake something. Lake something. Trust me, it's Lake something. Cha, I bet you could read my lips. No, I won't do that. Yeah, it was hilarious, Christy. Trust me. Just laugh. You'll be fine. All right. All right, here we go. Down to Florida, to that Florida guy.
Right, yes, ma'am, thank you. Hello, Mr. Walker.
Hello.
Mr. Walker, do you wish for me to appoint the public defender if you qualify financially?
No,
You're going to hire a private attorney?
no, I'd like to proceed without one. And maybe talk to the state's attorney about a possible plea deal.
Well, they don't even have an information filed against you yet. So to the state, can you make an offer before you have an information?
This is it's gonna be DOC, he's gonna score. So
Okay.
it's,
So even if you offered something, it would be to prison,
it will, he's gonna qualify for PRR, I believe, too, so.
which Mr. Walker, PRR is prison releasee reoffender. Don't you want me to appoint a public defender to represent you?
I only have petty theft, so I'm sure I don't qualify for that. I don't think
Well-
it's not a qualifiable charge.
Well, they're seeking prison against you.
Right, but that's not qualifiable for PRR, petty theft charge.
Okay, well, and you're going to represent yourself, Mr. Walker?
Oh, I'm supposed to talk to you?
Talk to me.
Oh, okay.
Okay, so,
Let me talk to you then.
okay, the state's not making you an offer other than prison.
Okay,
You don't have an attorney.
all
Do
right.
you want me to appoint an attorney? Or do you intend to
My
hire
question is, what does it mean the information is filed?
the charging document, the official charges from the state against you for the petty theft, the charges against you?
It's a mistake?
No, they just haven't, they have a certain period of time that they can file that against you. If they don't within that period of time, then you're supposed to get an ROR bond. But that time period hadn't expired yet. If I appoint an attorney to represent you, that attorney will know all that stuff. So don't you want an attorney?
Well, how long do they have to do that?
I can't give you legal advice.
I mean, is it not about to run out? Because I've been in jail for like 30 days.
You're
Yeah.
standing there alone, asking legal questions.
Oh, Yeah, I know. I don't know why they didn't appoint me one.
Okay, well, and I will appoint you one if you want one. Do you want an attorney?
Yeah, I guess so, because it sounds
Okay.
like he's got the wrong.
How much money do you make per month?
Pardon? About 2,500.
Okay. Did you
But I
work?
have a lot of bills and,
Okay. Because of that amount, Mr. Walker, I can't appoint you one right this second.
yeah, that's,
They'll give you a financial, okay, now listen to me,
I'm
okay?
listening.
They will give you a financial affidavit at the jail. Fill that out, load it up with those expenses that you have, okay? Because the clerk may say you don't qualify technically for a public defender because you make too much money. But if they send that back to you, there's a place that you can appeal it to the judge. And we have more latitude than the clerk does. So we can look at it and say, although he makes $2,500, he's got all these bills. There's no way he could afford to hire a private attorney, and we would appoint the public defender. Okay?
Okay.
So I'm not appointing them yet. I will see you back here in 1 week. I'll fill out that financial affidavit before that. Hopefully, when you come back in a week, you'll have an attorney.
Yes.
Okay?
Okay.
Thank you, sir.
All right.
Yeah, I'm not muted. So he said, you need a lawyer, you need a lawyer, you need a lawyer. How much do you make? Nope, can't give you a lawyer. Oh, man. I love it. Okay, so that helps. That helps. So if we have a real stressful clip, then one more like this will help bring us back down now. Oops. Okay. This is 10 minutes long because everything goes kind of slow in this courtroom.
What's your name, sir?
Charles Watson.
Thank you, Mr. Watson. Go ahead, counsel.
Your Honor, this is Mr. Watson. We've got 2 cases before us today, both in trial status. Cause number is 24L000540, cause number 24L000737. Your Honor, we have worked out a negotiation with the city to have Mr. Watson sign a non-driving declaration today, and we will also be I've uploaded a motion to continue on his cases. There's some further investigation that needs to be completed in his matter. And the basis for signing that non-driving declaration is so that Mr. Watson can proceed with his matters out of custody.
Ms. Schumacher.
I need to have defense verify speedy trial. I'm also looking for Mr. Watson. I have no objection to the motion to continue, but I just want to make sure we have that extra. I know we're going to get 38 more days of speedy trial, but I want to just confirm. Looks like speedy trial expires on 6/28. And the motion to continue is to June 18th. So we would need a further extension of speedy trial for the city to agree. So I'd ask if the defense is comfortable with the new commencement date of today.
I believe I've had the date that I put for the pretrial would be June 18th. Can we revisit speedy then?
No, I'm not going to agree to set it to June 18th with speedy trial running on June 28th.
That's because he's in custody. If 30 additional days are given, then speedy doesn't expire.
Then I'd ask that you put that on the order that speedy trial expires 30 days from the 28th, so July 28th.
Okay, understood.
I'm not seeing any of these orders uploaded on my end. Have they been?
The one that we're talking about has been uploaded, the Watson one. I have not gone through each defendant just to look, but I've been emailing back and forth and several of them have resolved. So I believe we should be getting orders uploading as we're moving along.
Thank you.
And Ms. Schumacher, it shows me that you're still editing. If you want to add that in there, I'm okay with that, or I can add that as soon as you're out.
Yeah, it won't.
Okay, it shows that you're out now, so I'll add.
Yeah, I can't figure it out. It says won't actually let me close even though it says I'm closed.
And I was not able to find a non-driving declaration in the documents prior to court. Do you know where that is?
I can look. You can also just put it in the continuance order.
Ms. Mon, did you not know that you'd be asking your client to sign a non-driving declaration before today?
I did, Your Honor, but I could not find it in the court documents.
I want to make something really clear. If an attorney is coming to court with a plan to engage in a resolution or a continuance or any action which requires a particular document, I would expect the attorney to arrive having prepared the documents or to know where they're at. My understanding is a non-driving declaration is under the DUI tab. So I am going to take a 5-minute break. I took this calendar started at 11:54, and I'm sitting here at 12:10, and I have meetings at 1 o'clock. We are stopping this calendar at 1 o'clock. Anything that is not done will be set over till tomorrow morning. And I do not want to come back and hear things like, I don't know where the documents are that I needed and knew about before the hearing started. So we are in recess and we will return at 12:15.
Thank you.
Okay. Do we have all of our forms and documents uploaded and ready
Yes, Your Honor.
on the whole calendar?
Yes, Your Honor, at least that's from my end, yes.
Okay, great. So returning to the Watson matter, we have a motion to continue that has been uploaded that I'm going to review at this time. Is there an agreement that speedy trial ends on July 28th, 2024?
Yes, Your Honor.
Ms. Mon?
Yes, Your Honor.
Thank you. Is the intention for this person to be released on personal recognizance? Is that the request of the parties?
Yes, Your Honor.
Yes, Your Honor.
Is Mr. Watson unable to sign the declaration?
Your Honor, yes, he won't be able to sign, but we can mark served on defendant.
Hello, Mr. Watson. I have in front of me a declaration to not operate any motor vehicle without an ignition interlock device. Have you reviewed this document with your attorney, Ms. Mon?
Yes, Your Honor.
All right. Do you agree to this condition in order to secure an agreement from the prosecutor to reduce your bail to personal recognizance and allow you to leave custody?
Yes, Your Honor.
You understand that this means you cannot operate any vehicle, whether or not you own the vehicle, without an ignition interlock device?
Yes, Your Honor.
Do you have any questions about those conditions for your attorney?
No, Your Honor.
All right. I'll accept your acknowledgement and indicate that you are serving this, that it is going to be served upon you. Okay. We're also going to order that we're also going to make that a condition of your sentence, or excuse me, not your sentence, of your release. I am going to grant the motion to continue your matter until June 18th, 2024 at 2 p.m. You're required to appear in person. Do you understand?
Yes, Your Honor.
We are going to release you on your promise to return your personal recognizance. You're not to drive a car without ignition interlock device, and all other conditions of release remain in effect. Do you have any questions about any of your conditions of release at this time?
No, Your Honor.
Wonderful. Can't seem to get into the order. I'm gonna reload. Oh my gosh. Courts is now not letting me do anything.
Mine is really slow.
Oh. Okay, I have signed the orders. I believe that concludes your matter. What's the next matter, please? And thank you, sir.
So if you see this courtroom, I played this a lot, sort of more at the beginning with Judge Mansfield. This is Judge Mansfield's courtroom. And Harwath Law is the law firm that they use for the public defender. And this prosecutor, she's sort of new. We had Emily. Emily was awesome. Emily was great. And then this prosecutor came. Now, this prosecutor constantly gets yelled at by Judge Mansfield. Constantly, because she's supposed to know that where the documents are. This prosecutor constantly cannot find documents. And that particular document, the driving one, this prosecutor took forever to figure out where it was. Like, she would get yelled at, and then the next case, she still doesn't know where it is, and then the next case, she still doesn't know where it is. And I've seen this prosecutor get chewed out. Now, this attorney is sort of new. She only came, oh man, within the last 6 months. So she's new, and this Oak Court system that they use, everybody hates it. It's just hard for everybody. So I understand why she can't find that document. Nobody can find that stupid document. It's in the weirdest place. And that judge just ripped her a new one. Now, normally it's the prosecutor that gets ripped a new one. So it was crazy that this pro tem, I think, judge comes in and rips her a new one. But there's more. But we're gonna relax a little bit first before we go into more. Don't worry.
Name for the record again?
Oakland.
Thank you. Detective, I understand there was an issue that came up at the jail.
Yes, Your Honor.
What were the circumstances?
Detective Vanderoff with the Royal Police Department. Your Honor, the bond conditions were set for Miss Dietz from 10:30 a.m. to 11:43 a.m. She has attempted to contact the victim, Mr. Hanna, 8 times. The phone number that she's going to call is 248. At 11:43 a.m., she speaks with Hannah for 5 minutes before disconnecting.
Okay, thank you. Counsel, would you like to address this matter?
Judge, in speaking with my client, it was kind of hard to understand her, but basically the gist of it, and I'll defer to her if she feels she'd like to comment on this issue, is she was trying to get a phone number for her mother and her brother to be able to come and bond her out. And whether she actually spoke with Hannah or not, I'm not sure, but that she was attempting to get a phone number for her from her family, and that's where there may have been some improper communication. I'll defer to her regarding that. Ma'am, would you like to comment further on that, Ms. Dietz? Go ahead.
I'm just trying to get communication that I don't have phone numbers for so that I can get out. His sister is here trying to help me. I don't have the phone number.
Okay, all right, so I originally said I'm gonna leave the bond where it is, 2,000 cash surety, no 10%. But I am gonna add one more condition based upon you violating the bond condition by contacting or attempting to contact Abdul Hannah, H-A-N-A. So the added condition based upon the bond violation is that you will be placed on a GPS tether prior to your release with a 3 to 4 mile hot zone from the residents of 1402 South Campbell in Roanoke, Michigan. I'm not going to allow you to even return there for one time only to retrieve any information. So I'm removing that one time only with police escort to go there. So a GPS tether is now ordered prior to your release on this matter. We have concluded the proceedings today. Thank you, Detective Counsel. Ma'am, good luck to you.
Thank you, Your Honor.
Yep.
Good luck paying the monthly bill on that. Okay, now that we're relaxed a little bit, let's get into it.
Sir, what's your name, please?
My name is Fernando Cortez Faust.
Oh, Mr. Faust, this matter is here on cause numbers 24L000226, a trial status, and 24L000502, another trial status, and cause number 24L000662, another trial status. What is the party's intention today?
Your Honor, there is a plea of guilty loaded in Oak Courts. The city is dismissing charge ending in 226, criminal trespass in the second degree, and charge ending in 662, theft in the third degree, both dismissals based on the court's acceptance of a plea of guilty to the charge 24L0502.
Thank you very much. Sir, I have in front of me a statement of defendant on plea of guilty. Have you had a chance to review this document with your attorney, Ms. Mon?
Yes.
And do you have any questions about this document before we begin?
No questions at all.
All right. I'm going to review this document with you, and then I'm going to ask Ms. Mon if she has anything to add before I take your plea on this matter. This document indicates that you will be pleading guilty to one count of assault in the fourth degree with sexual motivation, and that the crimes of criminal trespass in the second degree and theft in the third degree will be dismissed. Is that your understanding of the plea today?
Yes, I understand. I understand, Your Honor.
Okay. This document indicates that the charges for the crime to which you will be pleading guilty are contained in the charging document that was presented to you. Is that correct?
Yes.
Paragraph 5 indicates the important rights you give up anytime you plead guilty. They include the right to remain silent, the presumption of innocence, the right to appeal your conviction, the right to call witnesses without any expense to you, and other important rights. Have you reviewed these rights with your attorney, Ms. Mon?
Yes.
Do you waive these rights in order to allow us to proceed today?
Yes.
Do you have any questions for Ms. Mon about those rights in particular?
Yeah, no questions at all.
No questions at all. Paragraph 6 contains the agreed recommendation of the parties. The parties are going to recommend 364 days with 338 suspended, that you be given credit for time served in the amount of 26 days, that the matter is to close thereafter, and that you not receive any fines. Is that your understanding of the recommendation today?
Yes, that means I'm released today, right?
If I follow the recommendation, that is correct.
Okay.
You understand I do not have to follow the recommendation. The recommendation, I could sentence you up to 364 days and order a $5,000 fine, as well as any treatment that I think is appropriate. Do you understand that?
Yes, I understand, Your Honor.
I'm not asking today whether or not you're a citizen of the United States.
Yes, I am.
I'm not asking that.
Oh, okay, sorry.
Why has his counsel? Why was paragraph 6G not initialed?
Yikes. Somebody help her, please.
Your Honor, you said paragraph 16?
6G. I'm not a citizen of the United States. If I'm not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Defendant's initials. It's left blank. Why?
Your Honor, because I don't usually sign that portion or any portion of a document that is a guilty plea on behalf of my clients. They don't have the means to sign anything while they're in custody. But I can, on this record, make the record that I am signing that portion on his behalf.
Right. I've seen the initials typed several times before, counsel. Is that not something you're able to do?
Your Honor, I can type them in now. It's just not something that I've done before, but I can type them in now.
So, sir, you understand that if you are not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the U.S., or denial of naturalization pursuant to the laws of the United States. Do you understand that?
Yes, I understand, Your Honor. Do you authorize your attorney, Ms. Mon, to indicate your initials FF by that portion of the plea agreement? Yes, I understand.
But there's more.
Is there a registration requirement for this crime?
Your Honor, there is. And I believe I did mark the box for it. Just remarked it under W.
Sir, you understand that this crime comes with a
But there's more yet.
I see it is now marked. Is that correct?
And yes, Your Honor.
Sir, are you aware that if you plead guilty to assault in the 4th degree with sexual motivation, you are required to register as a sex offender in the state of Washington, which means that you have to report your whereabouts to the sheriff's department in the county in which you reside, and that those requirements may be, you may have to report multiple times or more frequently if you do not have a fixed residence. Do you understand that is a requirement if you plead guilty to this crime?
Yes, I understand.
In your plea agreement, there was a box when you signed it that was not checked, but is now checked. It indicates that pursuant to RCW 43.43.754, that if you plead guilty to this crime, you are required to have a biological sample collected for purposes of DNA identification analysis, unless it's established
that the Washington State Patrol Crime Laboratory already has a sample for a qualifying offense. Do you understand that's a requirement in this case if you plead guilty today?
Yes, I understand.
And just so your honor knows, I did review that with him when I was discussing his case.
So this does have a registration requirement?
Your honor, he's pleading guilty to assault in the 4th degree with sexual motivation.
Thank you for that. My question to you is, does it have a registration requirement?
The prosecutor should be chiming up right
Per
now.
the RCW.
Great. Which RCW?
43.43754.
.754 is a biological collection statute. It says nothing about registration. Is this a conviction that requires registration as a sex offender?
No, your honor. It requires, as you have stated, a biological sample collection.
When I asked earlier if this requires sex offender registration and was told yes, I then proceeded in my colloquy to advise your client or to ask your client if he knew the consequences. The reason I do that in a colloquy is I have to establish that this plea is made knowingly, intelligently, and voluntarily. To prove knowing, intelligent, and voluntariness, we have to prove under the Washington State Constitution and established case law that the person has been accurately advised about the law regarding pleas. If we fail to do that, we violate Mr. Faust's constitutional rights. I do not violate people's constitutional rights. When I ask if a statute applies, I'm not just asking as part of some academic exercise. I'm asking because it's important that your client does not have his rights violated by this court. If you do not understand my questions, Ms. Mon, I need you to ask to clarify them, okay?
Understood, your honor.
But I cannot have people in this courtroom while I'm attempting to protect the rights of a criminal defendant who is in custody guessing at the statutes that apply. Are we clear?
Yes, your honor.
Okay, sir. We're going to do this all over again. Because the information I got is inaccurate. So we're going to go back through.
All right, no problem.
I appreciate your grace. You're being very patient, Mr. Faust.
You're welcome. Thank you.
I have in front of me, Mr. Faust, a statement of defendant on plea of guilty. This statement of defendant on plea of guilty was reviewed by you with your attorney. Is that correct?
Yes.
Did she read it to you? Did you read it yourself, or was it a combination of both?
It was a combination of both, your honor.
Great. When you read it, there were two portions that were not filled out. One of those portions is paragraph 6G, as in gamma, which talks about the United States and what a plea of guilty will do to citizenship status. Since you reviewed this with your attorney, your initials FF have been added to that line, to the line on 6G. Do you understand that?
Yes.
Does that change your desire to proceed with this plea?
No, Your Honor.
Great. Also, a checkbox next to paragraph 6 X has been marked, which begins pursuant to RCW 43.43.754. Now that that has been checked, since you first reviewed this with your attorney, do you still want to proceed with this plea?
Yes, Your Honor.
Right. With those two changes to what you reviewed, I'm going to go through the plea. It indicates that you will be pleading guilty to assault in the 4th degree sexual motivation, and that the state will, or the city will, dismiss criminal trespass 2nd degree and theft in the 3rd degree. Is that your understanding?
Yes, Your Honor.
Also, it indicates the charging elements are set out in the charging document. Is that accurate?
Yes, Your Honor.
Paragraph 5 contains the very important rights you give up anytime you plead guilty. They include the right to remain silent, the right to be presumed innocent, the right to appeal, and the right to call witnesses at no expense to you, as well as other rights. Do you understand the rights that you're waiving in order to plead guilty today?
Yes, Your Honor, I understand.
Do you want to proceed having waived those rights?
Yes, Your Honor.
The joint recommendation of the parties as contained in this document is that you serve 364 days with 338 suspended. You pay $0 in fine. You receive credit for time served of 26 days in custody, and the case will close. Is that your understanding of the recommendation?
Yes, Your Honor. That means sorry for talking over you.
You're okay.
Which means I'll be released today, right?
That is the recommendation of the parties, correct.
Dibs.
Okay, thank you.
Dibs.
You understand I don't have to follow the recommendation of the parties. I could keep you in custody for 364 days if I wanted to in this case. Do you understand that?
Yes, I understand, Your Honor.
You understand the crime of assault in the 4th degree sexual motivation has a maximum sentence of 364 days and a $5,000 fine?
Yes, Your Honor, I understand.
You understand that if you're not a citizen of the United States, a plea of guilty to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States?
Yes, I understand, Your Honor.
You understand that a biological sample, meaning a DNA sample, will have to be taken from you after you plead guilty, unless it's been established that the crime lab already has a sample from you for a qualifying offense. Do you understand that?
Yes, I understand, Your Honor.
Has anyone made any threats or promises other than those contained in this now amended guilty plea in order to get you to enter the plea today?
No, Your Honor.
Do you make the plea freely and voluntarily?
Yes, Your Honor.
Paragraph 11 reads, on or about April 18th, 2024, in the city of Lakewood, I touched Ms. Alexis Petro in an offensive and inappropriate manner with sexual motivation. Are those the facts that make you guilty of this crime?
Yes, Your Honor.
Do you have any questions for your attorney before I ask how you plead in this matter?
No, Your Honor.
How do you plead?
May you say it again?
Certainly, and thank you for asking.
Oh, you're welcome.
Yeah. Do you have any questions for your attorney before I ask how you plead to this crime?
No questions.
How do you plead to the crime of assault in the 4th degree sexual motivation?
Guilty.
I accept your plea of guilty. I find that is knowingly, intelligently, and voluntarily made, and I do find you guilty of the crime of assault in the 4th degree with sexual motivation, and I do dismiss the crime of theft in the 3rd degree. I have the joint statement of the parties before me. Is there anything you would like me to know, Ms. Schumacher, apart from what's in the agreement?
No, it is an agreed upon recommendation. Thank you.
Thank you. Ms. Mon, anything to add?
Nothing further to add, Your Honor.
Thank you. Mr. Faust, you have what's called the right of allocution. You can say whatever you want, or you don't have to say anything before I pass sentence in this matter. What, if anything, would you like me to know before I pass sentence?
I'm so sorry for what I've done. And I realized the time that I was in jail, I realized what I've done, and I'm not ever going to do it again.
Thank you very much for your allocution, sir.
You're welcome.
I appreciate that.
I appreciate it so much for releasing me today too.
Well, I haven't. Okay.
I'm sorry. I'm just getting ahead of myself.
I haven't ruled yet, but I am going to follow the recommendation of the parties. I am going to order you to serve 338 days with 26 days credit for time served. And I'm going to close the file at this time. A DNA sample will be collected as is required. Wendy, can you review, please? Ms. Mon, please review and sign if accurate.
Carefully, because apparently they'll attack you and the town.
No. Was one issued in this case?
And that's been signed, Your Honor.
All right. I have signed the order. And that concludes your case, Mr. Faust. Have a great day.
Does that mean I'm released today, or?
You will be, yes.
Yes, thank you so much. Yes.
Have a great day.
Thank you for being my judge. Thank you for being my, yes. You guys have a great day. Thank you, ma'am. Thank you, ma'am.
You have a good day, Mr. Faust.
Thank you.
Okay, Nisqually, thank you.
I've seen this lawyer many times before, and I'm telling you, she's the one on task, and the prosecutor is the one getting chewed out. Yeah, he's coming back. Absolutely coming back. All right, let's de-stress. We're going down to Florida again.
Good afternoon, sir. How are you?
It's too early to tell.
Yes, sir. Okay. 1 second.
I'm sorry.
Okay, wait a minute. I'm sorry. Your last name is?
Sawyer.
Sawyer.
Like Tom Sawyer and Huckleberry Finn?
Yes, sir. Absolutely. Got it. Number 9. I just skipped your paperwork. Because I don't. Here we go. It's stuck to another sheet. Got it, Mr. Sawyer. So you filed a motion for ineffective assistance of counsel, and basically made a statement that he doesn't have your best interest at heart. Do you still wish for me to discharge him and appoint another attorney for you?
Yes, sir.
Okay. If you'll raise your, I'm going to get some testimony from you. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Okay, you can put your hand down. So here's what I have to find for you to prevail, for you to win. I have to find that Mr. Koch provided ineffective assistance of counsel, okay? So tell me what facts you believe support that.
All right, I guess I'll start from the most recent.
Or if you, let me interrupt you. Or if you think he has a conflict, you say, he doesn't have my best interest at heart. If you're saying he doesn't have my best interest at heart because he knows the victim or, something like that, tell me that too.
Well, Judge, I had wrote this for you last night. Is it
Okay, do you want to read it on the record? Or do you want to just file it and I'll read it?
I mean, I could read it, but if I wrote it to you.
Well, it's going to be entered into, there can't be an ex parte communication, a one-party communication. Whatever you tell me, I've got to share with the state. So either you read it or we'll hand it to the state and let them read it and then I'll read it.
So,
But it can't be
I never
confidential
really-
between you and me.
I never did this before, so what would be my best thing? Finish this hearing between the ineffective counsel and then we give this to the state?
I need whatever evidence, whatever facts you believe show that Mr. Koch is rendering ineffective assistance of counsel. I've got to find that for you to win today.
Yes, sir. All right, well, I will start, when I first took probation.
Okay.
All right, I am an addict. I have a problem. I've been shooting up heroin for like the last 8 years. And I stressed that to Mr. Thomas, upon the week before I took probation. I said I got accepted to the Hope House, ECLC, the Keaton. Well, can you please, the only way I can get in there is if you sentence me there. He said, all right, we'll take care of that. So I come to court and he says, you got 2 years of probation. Now, I would assign 10 years of probation just to get out there and do another shot. I have a problem.
Yes,
all
sir.
right? And so I took probation, not knowing, really thinking about the stipulations because I shoot up heroin. I need help.
Yes, sir.
Okay? Now, fast forward till now.
Good.
I've been in jail for going on 3 to 4 months. I've seen him once. And the only person that I have to help me justify what I'm being, I admit that I am totally guilty of my actions, but I'm not guilty for the charges I am charged with. And that is totally wrong. And I just feel like I haven't seen him but once. And every time I come to the podium, he says, don't say nothing. I'll come see you, but he never comes see me. Now, I understand this is a waiting process and the state wants a conviction or something. I don't know, but I got a 6-year-old daughter I'm trying to get back to.
Yes, sir.
I appreciate being in jail. It got me clean. I really appreciate it.
Yes, sir.
But I still feel like I need help. And I got accepted in the drug court. I would love to read this, if you don't mind.
So other than Mr. Koch, it sounds like that your argument is that you've only seen him one time in 3 months, and because of that, he's rendering ineffective assistance.
Yes, and because I'm being charged with crazy charges.
Yes, sir.
They offer me PLC time.
Any other facts you want to tell me about him rendering ineffective assistance?
Okay, so I only have one person out there we reached out to him multiple times and only got to his assistant. I think her name's Katie or something, trying to give proof to defend me on the charges that I'm charged with.
Okay.
Because I do have a medical marijuana card, but I'm charged with not having it. That's a felony.
Okay.
And it's just a lot of stuff that's going on that I shouldn't be charged with these charges. Anything I trespassed and had a simple possession. But that's the only way that I would be guilty. You know what I mean? I didn't burglarize nothing.
Okay. Okay. Mr. Koch?
Yes, Judge.
You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Thank you, sir. Mr. Koch, tell me why you are not rendering ineffective assistance based upon the allegations and the testimony of your client.
Yes, Your Honor. I'd like to first address the new charges. My client was arrested on March 13th, 2024. The next date for first appearance to the public defender's office was appointed. So 3/14, we were appointed. I'm not even addressing time to open a file, but I saw Mr. Sawyer on April 2nd. So it puts it about 18 days later after he was arrested. I did address that the 23 CF 243-2, he was violated on because of these new pending charges. And at that time, I saw him on April 2nd. I told him no information has been filed yet, so we'll have to go through arraignment. About on 4/13 is when Mr. Sawyer sent the motion for ineffective counsel. So from when I saw him on April 2nd, 4/13, at that point, I wanted to wait for us to have this hearing. Of course, discussions with my client stopped when he writes to this court to address this issue. So I saw my client, I just say 18 days after we got appointed. Once he sent correspondence to this court wishing to get a new attorney and I was ineffective, I ceased talks.
Understand. Okay.
And if I could just address the 23 CF 2432, I conveyed the offer that was given by the state attorney's office at that time for the probation offer. Of course, the option of trial is always an option, but my client wanted to take that offer at that time. So we entered that plea on December 14th.
Understand. Okay. Mr. Sawyer. I take what you told me about your addiction. I had someone that was being sentenced a couple months ago that was an addict, and he was homeless, and he said, we will do whatever it takes to get the next fix. Made a big impression on me, especially being homeless and having camps next to other addicts and being concerned about what they may do to you. So when you say that, when you say, I will do anything to get out of jail, so I took the 2 years probation, a lot of validity there. So I understand that, I believe you. But the only thing that you've alleged as far as ineffective assistance is Mr. Koch not coming to see you. And once you filed this motion, ineffective assistance of counsel, it was docketed on April 18th. It was dated April 13th. It took a while for it to be filed with the clerk. Then the attorney stopped communicating with you because they need this ruled upon before they can represent you and keep going on your representation. So there aren't any real facts that get any traction with the court because he was appointed on the 13th. You filed this motion on the 13th, a month later. He saw you in between that. So I do not find that he's rendering ineffective assistance of counsel. I do have some concerns from my perspective that this was filed on April 18th and now it is a month later. As soon as I get one of these, I read them. If it is something similar to this, I say set it for a hearing. So I'll make sure I'm more vigilant. I'm sorry it took a month for it to get from the time the clerk filed it to get here because your attorney's not doing anything on your case for that month. But respectfully, your motion's denied. So Mr. Koch continues to represent you. Mr. Koch.
Yes, Judge.
So is Mr. Sawyer's case set for July 8th?
Your Honor, I believe we haven't addressed it yet because I believe we wanted to have this here
Okay,
today.
good. Yes, sir.
I would like to set all three cases, the one VOP and the two new laws, if we can, for that July 8th pretrial date.
Okay. So Mr. Sawyer, I'll see you on July 8th. Thank you, sir.
Not only does it have those little ads scrolling across the bottom, Okaloosa Court TV plays commercials when the judge takes a break or when they're waiting for the next person to come up. He plays full commercials in between the docket. It's funny. But no, I don't have a sponsor. None of those are for me. Okay. We got one more. We have one more go, guys. But this one is way shorter. All right. We're going back to that judge with the eyebrow and that poor attorney. Here we go. Oh, I don't want to click it. I don't want to click it. I'm trying to. Here we go.
Right, needs to be addressed is not a plea. That's a review and sanctions being requested by the city. Number 10 is an arraignment that needs to occur. Number 14 looks like it was competency. I have not heard from defense what the plan is on number 14. We could start with either the arraignment, number 10.
Here's what I'm going to do.
Ms. Job is not. Ms. Job is.
Here's what I'm going to do. Number 4, Christopher DeFalco. What is your intention with that one, Ms. Mon?
That was rescheduled, Your Honor. That's a Resnick matter.
Not on my calendar?
Not on the calendar. Okay. Strike it. Thank you.
Okay. Mr. Jimenez, we're going to set that one over.
Rochelle Job, what's the intention?
Arraignment today. That city is ready.
She is a refusal.
All right, we can sit over to Friday.
Tomorrow, hold on just a moment, tomorrow morning, or
Oh,
we'll prepare an order for that one and set it over to tomorrow morning because this is the second refusal in that.
okay. Thank you.
Rachel Thompson.
She is also a refusal. I've not been able to speak with her.
Okay, set that one over to when? Friday. Okay. Okay. So, Mr. Jimenez, unfortunately, we're going to set that one over to Friday. Please prepare the paperwork, Ms. Bond. The Rochelle Job, that matter we're going to set over to tomorrow morning, and I will ask Wendy to please get me an order prepped, and I will deal with that issue. The Satterthwaite, is that one's a plea?
Satterthwaite is a review and city seeking sanctions, or at least we need to discuss it on the record.
Set over to Friday. The Twai, Mr. Twai, I'm sorry. It doesn't sound like there's actually an agreement between the city and the defense, so I can't proceed in this case yet.
Your Honor.
So I'm going to set it over to Friday. Yes, Ms. Mon?
Is it okay if we set Mr. Twy for tomorrow?
No, Friday. So it sounds like, yes, Mr. Twine?
I've been asking to take treatment when I get out. I've been trying to take care. I have my family out there going to Crossroad doing some treatment. That's why I was like, most movies today will be the day, but I guess not.
Yeah, that's good. I'm glad to hear that. And I think since we're here, you will get, I just don't know what they want to do is the problem. I don't know what the parties want to do on that one.
Mr. Tawai, if the defense is going to agree that I'll get an alcohol assessment and standard DUI conditions, which is customary in every amendment from a DUI to a negligent driving, standard conditions means standard DUI conditions. If the defense is going to agree to that and add it to the plea, I have no problem proceeding today.
Okay. Okay, so here's what we're going to do. Here's what we're going to do. We're going to take the Jimenez plea. We're going to take the Tawai plea. If you two can get, if not, sorry.
No, that's
that
fine.
was disrespectful and I apologize to you both. If the parties can get to a place where they agree. I'm going to take another 5-minute break.
Thank you very much for your patience, Your Honor.
Certainly. Apart from the Tawai matter and the Jimenez matter, all the other matters, I don't need to see the defendants. They can go back because the parties are going to prepare motions to continue and we're going to set them over. And then if you can prepare for me that order on the on that other matter, Ms. Job, then we should be ready to go. I'll return in 5 minutes. We're at recess.
Well, he in fact does not return in 5 minutes. That was the end. He never came back on. So we don't get to see him roast poor her anymore. She's done being roasted. Okay. Now we're going to go across the pond. This one isn't funny. It's interesting. It's just 15 minutes and it's just very interesting. Here we go. And we get the wig that we didn't get from the Australian courtroom. We do get the wig. Don't worry.
Jacob Graham, on the 22nd of February this year, you were convicted of terrorist offences by a jury after a trial which lasted over 5 weeks. Those offences were firstly of preparation of terrorist acts contrary to Section 5 of the Terrorism Act 2006. That was count 2 on the indictment. 3 offences of possession of a document for terrorist purposes, contrary to Section 58 of the Terrorism Act 2000, being counts 3 to 6, and 2 offences of dissemination of a terrorist publication, contrary to Section 2 of the 2006 Act. You are age 20, being born on the 22nd of January 2004. During the time you committed these offences between May 2022 and May 2023, you lived with your mother, your sister, and her partner in the Norris Green area of Liverpool. You were a student and appeared to those who knew you to be an ordinary young man with an interest in fireworks, the military, and outdoor pursuits. You were aged 18 and 19. In reality, however, you were a dangerous young man. You described yourself as the first homegrown UK terrorist. It was only your uncertainty about whether someone else held that claim before you that caused you any doubts, because you were proud of that claim. You held a clear and settled intention to assist others to commit acts of terrorism. You searched the internet for information and files that explained how to make explosives, weapons, and ammunition for the purposes of terrorism. You collected a very substantial quantity of documents and videos, which you provided to many others, whom you knew shared your interest in extremist activity and in planning terrorist acts. You even wrote your own document with step-by-step details of how to make explosives, ignition devices, weapons, the destination of improvised explosive devices, IEDs, and how to treat law enforcement authorities. You called it Freedom Encyclopedia, and it was addressed to, quote, to all you misfits, social nobodies, anarchists, terrorists, future and present, and anyone who wants to fight for freedom, close quote. Whilst during the trial you denied writing that particular passage on the front page of the document, you still promoted it online, both within encrypted chat groups and in an open source video platform, even when you knew it was written. During your offending, you became a member and controller of chat rooms on the internet, mostly encrypted to hide what you were talking about. Over many months, you discussed in group chat and direct messaging, planning and preparing for terrorist acts. You were the administrator, solely responsible for those who could be in the group and who could not. One of those groups was called Total Earth Liberation Group with 150 members. Discussion included assistance with information on how to make explosives to attack energy infrastructure sites and commercial entities, how to make a rudimentary shotgun about poisons and napalm alternatives. You offered yourself as a very knowledgeable and experienced terrorist. Whilst you were not telling the truth about what action you had taken, you were building trust and providing information which they wanted from your digital library of information, which was likely to assist a person preparing acts of terrorism. Particularly disturbing was a document you wrote entitled My Letter, which you wrote over a 3-month period in 2022. In it, you said the following: if you're reading this, then it means I succeeded in my plan. People who have privilege and still complain about their life deserve the privilege taken away from them, and that's what I'm going to do. I'm going to attack government buildings, politicians' houses, mass murder those who think it's okay to hide their wrongdoings behind money and power. I do not see this life worth living for much longer, so I may as well go with a bang. I do not have a date or set targets, but I'm aiming for at least 50 deceased and more injured. Any more is a blessing. My plan is simple and straightforward. I will start a bombing campaign. The planning and manufacturing of the plan will take time. I am estimating 3 to 5 years, but the more time I give, the bigger the target, close quote. During the many hours of recorded video you made, in which you explained in graphic terms your terrorist intention, you referred to My Letter, and although the jury did not convict you of personally engaging in conduct in preparation for acts of terrorism, you described your wish to carry out a terrorist act in which many people would be killed. In evidence, you told the jury that you were only interested in chemistry, pyrotechnics, and the military, and that you just had a strange hobby. That was what you told the police when interviewed, and also the author of the pre-sentence report. The jury rejected that explanation when they convicted you of these offences. Whilst that might have been your starting point when you were younger, it was not what you were doing during the indictment period. Far from it. I am satisfied that you are a dangerous offender. During 2022 and 2023, you had a terrorist intention which caused you to create your Freedom Encyclopedia document and send it to others to assist them in engaging in or preparation for terrorist acts. You collected a very substantial quantity of digital files which were likely to be useful to others in those acts, and you disseminated to others information in the form of digital files intending to provide assistance in the commission or preparation of terrorist acts. You were not merely reckless in that assistance. I'm sure, as was the jury, that you intended to assist many others. Further, the author of the pre-sentence report was asked to consider your risk of harm to the public, concluded that you present as a high risk of harm. For these reasons, I'm satisfied that there is a significant risk to members of the public of serious harm by you committing serious specified terrorism offences. I am also sure that the seriousness of your offending was aggravated by the period of time over which you committed these offences, the substantial volume of terrorist relevant information which you had acquired, the fact that you conducted your discussions through encrypted messaging with members of your chat room who were obviously people with extreme views. The fact also that you promoted your Freedom Encyclopedia in an open online video platform and you acted out some of your extremist views when you secretly buried a cache of chemicals in remote woodland, sufficient to create a low explosive, is part of these aggravating facts. I take into account in mitigation the seriousness of your offending, that you were aged only 18 and 19 at the time and are now only 20. You have good character and no previous convictions. You have also been the victim of witnessing domestic violence whilst you were growing up, which has caused you some psychological harm, as referred to in the psychological reports of Dr. Harry Wood, dated the 30th of October and the 19th of November 2023. He concluded that you have some symptoms of complex PTSD, including nightmares, hypervigilance, and avoidance of stimuli associated with traumatic events. I have in mind, however, the guideline relating to mental disability, but I am not persuaded that your PTSD symptoms have any connection with the culpability for your offending. Whilst it is argued on your behalf that you have changed your mindset away from terrorism, I am not persuaded that you have done so substantially. In the trial, you said that you were appalled by what you had written in my letter in that document. You did not say the same about the other documents you created, possessed, or disseminated. Also, in the pre-sentence report, it is clear to me that you tried to minimize your responsibility and maintain your innocence. In sentencing you, I shall treat count 2 as the lead sentence, which means that I will take into account counts 3 to 8 to increase it, but impose concurrent sentences on those counts. Each of these offences is a specified terrorist offence under Schedule 18 of the Sentencing Act 2020, whilst count 2 is also a serious terrorist offence under Schedule 17A of that Act. I have concluded that a serious terrorism sentence is not appropriate for count 2 because I cannot be sure that the risk of multiple deaths by your offences was very likely. However, I am satisfied that an extended terrorism sentence must be imposed on count 2. It is a specified offence. You were over 18 when convicted. You are a dangerous offender. Neither a life sentence nor a serious terrorism sentence is appropriate, and your custodial term will exceed the minimum required. Under the guideline for Section 5, Preparation of Terrorist Acts, Count 2 falls within Category C2. In terms of culpability, because you acquired training or skills for the purpose of terrorist activity and your acts were a significant assistance or encouragement of others. In terms of harm, multiple deaths were at risk, but not very likely to be caused. The starting point for sentence is therefore 15 years with a range of 10 to 20 years. The aggravating factors, including counts 3 to 8, increase that sentence above the starting point, almost to the top of that range at 19 years. But the mitigating factors reduce it to 17 years. I reduce that term further by slightly more than 25% to reflect your young age to a custodial term of 13 years. I'm required to assess the period of extended license, which I determine at 5 years because I consider it's necessary for the protection of the public. That means on count 2, you will serve an extended sentence of 18 years, of which 13 years is the custodial term in the young offender institution, and the extension period is 5 years. In relation to counts 3 to 6 and counts 7 and 8, I do not impose a special sentence, given the extended sentence I have imposed on count 2. On counts 3 to 6, I'm satisfied that those offences fall within category B2 because culpability falls between categories A and C, and the material provided for specific terrorist activity endangering life, which was not very likely to be caused, or had the potential to cause widespread damage to property. The starting point for sentence is 6 years and a range of 4 to 7 years. After taking into account the aggravating and mitigating factors, as well as your age, the sentence is 4 years detention on each of those counts concurrently, and also concurrently with the sentence on count 2. On counts 7 and 8, I'm satisfied that those offences fall within category A1, because it was your intention to encourage those to whom you disseminated material which provided instruction for specific terrorist activity endangering life. The starting point for sentence is 10 years and a range of 7 to 14 years. After taking into account the aggravating and mitigating factors, as well as your age, the sentence is 8 years detention, which will also be served concurrently.
That is not very splendid of you, Amy, dear.
With all other sentences. Stand up, Jacob Graham. The sentence I impose on you is an extended sentence of detention in a young offenders institution for 18 years, comprised of 13 years in custody and an extension period of 5 years. The time you have served on remand is agreed at 290 days, which will be deducted from your custodial term, providing a period in custody of 12 years and 75 days. I impose concurrent sentences of 4 years detention, each on counts 3 to 6, and 8 years detention on counts 7 and 8, also to be served concurrently with all other sentences. Your extended sentence means that you must serve 2/3 of the custodial term before you apply for parole. It will be for the parole board to make the decision on your release up to the date you complete the custodial term. Upon your release and until the end of the extension period, you will be the subject of a license, liable to recall if you breach its terms. You'll also be the subject of the notification requirements under Part 4 of the Counter-Terrorism Act 2008 for a period of 30 years. That means you must notify the authorities of essential information about you for that period, failure in which means you will commit a further offence. I also make the deprivation order under Section 23A of the Terrorism Act 2000 in respect of those items on the agreed schedule, which I am satisfied to the criminal standard have been or are intended to be used for the purposes of terrorism. I make a serious crime prevention order in the terms of the application for 5 years following your release from custody. Finally, you will pay the victim surcharge in the appropriate amount, which will be recorded on the court order for your sentence. Taken.
That's what he was doing, teaching and selling terrorism in the UK. He didn't actually ever do anything. No one ever got hurt. 13 years. He got 13 years in jail, and then he's going to be on probation for the rest. Crazy. I mean, I do have one more. It was only from 2 days ago. It's awesome. It's an amazing clip. It's 21 minutes long. However, I think you guys might have all seen it. And I'm just so mad because that's my judge. He's the voice. That voice, though. He's that judge. He's that judge, that voice. I know, Carolyn, I know you saw it because it's the hillbilly interpreter you were talking about. Should I play it? You guys, listen, how about this? I'm gonna play it because I love this voice. And if you already saw it, then just pop over to my Discord and be done for the day. You've put enough time in. This is overtime. This is bonus overtime. So if you've already seen this, then you just dip. If you haven't seen it, get ready because this is so good. And that voice though, I can't wrap my head around what it would be like if he was screaming at someone, yelling at someone. I mean, I don't even know what it would sound like. She can too, guys. She really, really can. She can translate hillbilly like no one I know, not even any of the hillbillies I know. Oh, Cha, there's no way you didn't see it. It's so good. This is so good.
Yes, I can hear you. If you was over there, you couldn't hear me.
Yeah, I don't know what was going on down there.
That voice.
All right. So this is cause number, the particular case that I'm calling right now, and I know there are several cases, but is F02924, because that's the case I have set for jury trial on Monday.
Actually, my first case was about almost 3 years ago. It's supposed to be a jury trial.
Well, this is the first one.
Only case, though.
Yeah. Well, this is the case that we're going forward on Monday. Is a possession of methamphetamine for 200 grams. And so I want to make sure, I know that Mr. Phillips back on April 11th, we had a hearing and you had rejected a plea offer of 28 years on 2 of the cases and 15 years on 1 of the cases that were all supposed to run concurrent. And at that time, said that you wanted a jury trial. I want to make sure you understand certain things. First of all, that's the case that we're going forward on would be a second-degree felony, punishable by 2 to 20 years. However, the state's alleged 2 prior final felony convictions, one from March of 1981 in Dallas County for the offense of rape, and another from 2005 in Dallas County for the offense of robbery. If the state can prove those 2 prior final felony convictions, then the punishment range is 25 to 99 years or life. And so I want you to first of all understand that. Second of all, as to some of the other cases, the other 2 cases, one of those is also alleged to be a habitualized offense punishable by 25 to life. And then I think one of them is enhanced to a second-degree felony, so it's punishable by 2 to 20 years. By trying them, if we were to try these cases separately, there would be the option of punishment being stacked one on top of the other. But I want to warn you, first of all, about the ranges of punishment, that if the jury finds these 2 enhancements to be true, they start at 25 years and they can go as far as 99 or life. Last month, we had a case that was a 2 to 20 year case, and the jury gave who had no prior convictions, 18 years on what we would call a 3G offense. And the month before, we had a case that was 25 to life. But unlike these cases, that case had no opportunity for parole, was day for day. The defendant was 25 years old and had no priors, and the jury gave him 75 years. So he will be over 100 before he's eligible to, or not eligible, before he is released if he lives that long. So Hill County juries are very unforgiving. I want to warn you about that. I think I already told you that once.
Must be pretty forgiving. They forgave Kirk Cox for all that shit they stole from the county. He's out there delivering stuff out there across the corner right now in a UPS truck. So he's got to get us to sell his dope and guns and shit for him.
Well, Mr. Phillips.
I want to tell a jury. Why can they give people like that house arrest, never go to jail, come ask us to sell the stuff, dope and guns and shit for them? Me and Tim Claren, that they got stuck in jail for 25 years right now. No, but they're going to go back 40 years on a phony ass cases on me because they can't try me for what I suppose.
Well,
going on 69 years, this up there. I have never had a dope charge in my life, not even a paraphernalia case, until they got mad at us for not selling the drugs and dope and shit for them.
Well, here's what I can.
Down on me and got my niece Tamara there and sold her in prison, put Tim there in prison. Now they got it on me.
Well, yeah. Mr. Phillips, all I can tell you is Monday morning.
And this spirit tactic shit, y'all guys, but dragging us to pass. And I'm gonna get alive for that because this is all these phony charges we put. I got 8 damn charges here. And I'm even paying for a Garcia Phillips' damn hospital bill here in jail because they think y'all subpoenaed me for a jury trial under Garcia Phillips. I am not Garcia Phillips.
Mr. Phillips,
out here in my pocket that subpoenaed me to court on the 20th and 21st as Garcia Phillips. Our court ain't even run right.
Well, all that the jury will decide.
I'm going to speak before the jury. And Dickhead Honey better not show up. I done told him, I fired him 8 times. Told him to get out of my face. And I'm in it. He works for the DA's office, not for me. He is not even concerned. He has not done a thing that I asked him. I was there, he runs up. I think you better cop out for this. You know they gonna go up. Come on, I'm tired of all those damn jokes the court does.
All right. Well, Mr. Phillips, here's certain things
I know all
we need.
But no phony ass shit. That's what I'm gonna tell them. The jury, everything I know.
Hold on. Victoria, people were coming in tonight asking why weren't we playing Judge Fleischer. They thought we were going to see Judge Fleischer. He hasn't even been in court in 3 days. No. Anyway, hi, Victoria. I hope you guys have a good day in court today. I hope Melissa's back and Stephen does a good job. Is Stephen taking the assistant clerk position? Because that's open right now, right? Yeah, I know, Vicky. It's so funny. Oh yeah, maybe. Fozzie, you're right. Maybe there won't be court today because of the electricity. Oh man. All right, I'm going back. I needed a breath. I need to catch my breath. Here we go. Ready?
All right. Well, Mr. Phillips, I'm going to give you one more opportunity, and then you're going to either. Well, at this point, you're just going to listen, and I'm going to talk. That's what's going to happen. If this case goes to the jury, as I've told you, it's 25 to 99 years or life. You need to determine whether or not you want. If you are convicted, whether you want the jury to assess punishment or whether you want the court to assess punishment. So at this time, I'll ask you that. Which one do you wish? Do you wish, if convicted, for the jury to assess punishment or for the court to assess punishment?
They have it muted currently.
Yeah, now it's muted on that end if there's anybody in there.
Right now, Mr. Phillips, it's muted, so we can't hear what you're saying. They'll turn that microphone back on for you here. You'll need to sit him back down in his chair.
If there's anybody down there in the room with Mr. Phillips, put him back in his chair and turn the microphone on. Looks like he's in there by himself.
I haven't seen that before.
Well, I haven't either, but
normally they're not in that room.
Voice. Only Carolyn understands what he's
that's
saying.
true. That's a different room.
Hi, J Fire.
Say we need y'all to come on in here and
yeah. If you all will put Mr. Phillips back in his chair and turn the microphone on, please. Jailer, if you can hear me, if you'll turn the microphone back on. All right, there we go. All right, thank you.
No problem.
All right, Mr. Phillips, which one do you want if convicted? Do you want the judge or the jury? You want the jury. All right. The court will make sure that then the jury will be the person or the entity that will assess punishment if and only if you are convicted. Now you've been doing nothing but complain about Mr. Dohoney. He's a good lawyer. He's going to do everything he can for you. Well, here's your choices.
How come everybody fired him?
I don't know what you're talking about, Mr. Phillips. Nobody hires and fires court-appointed lawyers other than me.
3 years. And he hasn't done a thing for me.
Well, Mr. Phillips,
again, signing for time.
Well,
I'm going to let the jury know that they've been offering me deals and coercing me, scaring me. I'm going to let them know it all.
Well, if you want to represent yourself, you can represent yourself. Do what?
And I got 2 witnesses that went over to the courtroom with me when they threatened me.
Oh man, if only that Sav sit in Fleischer's courtroom had those 2 witnesses. That's all he was asking for. This guy got him.
Phillips.
I'm all his damn line about talking shit to me.
All right, Mr. Phillips.
How come they won't let me subpoena my witnesses? Have them in court. I've got 4 witnesses I actually would like to be there, but that's all they won't even talk to me. Nothing other than to try to scare me and to sign me for time. It's the only thing that Dick Honey will do.
Well, Mr. Phillips, if you wish to represent yourself, you can represent yourself.
I signed papers 3 years ago when I first started this crap with y'all. To represent myself in a jury trial, but they told me I couldn't do it.
Well, I'm going to tell you this.
Oh, you can.
If you choose, yeah, and I'll let you represent.
I signed papers to do it.
I don't have those papers. I will send you a waiver of counsel, but Mr. Downey will be there as what I call standby counsel.
They sent me a letter I had in my pocket where they said I have to have him as my attorney, which is a damn lie because I fired 3 of them in Dallas one time.
All right, let me finish talking before you jump up and down. If you want to represent yourself, I'll send you.
And I signed the papers to do it.
All right, and then keep your mouth shut so I can explain it. I will send a waiver down there. You sign it. I'll put you back on here and explain it so that we've got a clear record.
Don't you give me the court.
And then.
Don't really piss me off.
Well, that's on you, not on me. The other issue is, even if you represent yourself, you will be required to follow every rule of evidence. You'll be required to have courtroom decorum. You're not going to be doing this business like you're doing now, trying to talk over everybody else.
Well, why y'all pulling me trying to offer me deals with illegal? You guys make deals
I'm not trying to make any deal with you. What I'm trying to do is get ready for the fact that I'm having a jury trial Monday morning.
Get me out of here and offer me. Come on, man. I ain't stupid, man. I'm 74, well, 69 years old. I ain't retarded. So when a mother keeps on offering you time, dragging you and offering you time again and threatening you, well, my jury, I'll tell them to give you life. I'll stack all your charges, every one of them. And I got witnesses to stand up in the court and say exactly what I was told. That is
the other thing you need to figure out is, as far as I know, you don't have any appropriate clothing for a jury trial.
I just tried them on a while ago.
Did you?
An hour ago.
They have clothes down there for you.
Yeah. That dumbass told them I didn't have no one to bring me clothes. I have a sister right there in Okaloosa, and I've got all the clothes and then the mall out here at the edge of town. I have them right there in my house.
Well, your sister, I believe, has received a subpoena to come testify from Mr. Downey on your behalf.
And I have spoken to his sister, about potential for clothes. I've also, listened to a phone call of his dated April the 13th, in which he'd indicated to her that he didn't want any clothes. But I believe now that it sounds like this is the first time hearing it, but maybe they've got that clothing situation worked out, and that sounds good to me.
Excellent. As long as you've got appropriate clothing, I don't want you in front of the jury dressed like you are right now.
Like y'all make a dress. I know it's got to make y'all look like y'all have it. I know all that. I tell you, this ain't my first rodeo. I've been dealing with the law 45 years.
Oh, I've looked at the notice that the state's filed. You're well versed in the penal code of the state of Texas and the punishment range. I'll give you that.
Texas.
So, with all that being said, I will send a waiver of counsel down there. I will pull you back up after lunch and talk with you about it. But Mr. Honey will be. I'll ask him to stay on standby in case you need to ask anybody a question. And I can tell you, I think you're making the biggest mistake of your life, but that's up to you.
My life's almost over.
Well, I don't know. Man's 69 years old. I would hope he's got a bunch of years left in him, but if you think not, maybe not. But that's up to you. And then the other thing, of course, is if you choose to testify, then you will be waiving certain rights at guilt innocence, including the right to not.
Like I told him on this last trouble, I am guilty of the last one. Actually, I am. I had the dope on me. Yes, I did. But the other one, I didn't. I had a police woman that actually stopped me that seen him pull the shit out of his pocket after she had done searched me, my truck, the ground, everything else, and said, hey, look at what I found. Because it just stopped my niece and her boyfriend that night before that.
Well,
got it out of their truck. They put it in his pocket. They was asking to get me. So they got a baggie from Cameron Sheriff and Carl Waddell, which he's a police informant. So that ought to go a little.
Well, I don't care about all of that. All I care about is
Your Honor, and I'm not saying that I wouldn't attempt to introduce his statement that he did have dope on him in this particular case. It's going to trial Monday, which he just stated here on the record a moment ago.
I told him I did. Then, but the first one I did, I was set up.
Well, we're not talking about any of them except the 24th of October, 2023, Mr. Phillips. That's the only case I'm talking about on Monday. And so you just said that you had it. I have a feeling that'll get.
If I'm guilty, I admit it. I didn't beat the law no kind of way. But I hate being lied on. It's like that story at the Honey's right there, man. Blake gave a kid. Lying ass bitch, she was 43 and I was 24.
Well, so there's nothing that anybody can do about going back from a case from 1981.
Oh God! Well,
it is too late to worry about a case from 1981, Mr. Phillips. Either you got convicted of it or you didn't. And that's
Then I got convicted. I pleaded no contest.
well, and no contest has the same legal effect as a plea of guilty, and that case can be used.
That case, I only got 5 years.
Well, that's fine, but that counts as one of your 3 strikes.
I get out.
So, all right, well, Mr. Phillips. Let's see, Mr. Dohoney, anything you wanted to bring to the court's attention?
Just that I would reiterate my advice to Mr. Phillips that he should not testify or make any type of statements in the court or to the court that could possibly be used against him. I would against him representing himself as the court has done, and I think admirably. But I will certainly be, as the court has requested, standby counsel, so I will be there. So please that the jail has or someone has gotten him closed, and I will also file on his behalf as he has requested an election to punishment this afternoon, stating he has elected a jury. If the court could, I guess, provide me with the waiver once it comes back, I would appreciate that as well.
Now the prosecutor, here we go.
Your Honor, the state certainly is not encouraging him to represent himself. I don't think that's a good idea for him to do that either, but I do realize that he has that right. And if he goes forward with that and the court approves it, we'll certainly handle it as such. Because he's at least twice, I guess, now during this proceeding indicated that he did have those drugs, and I think he said he was guilty of that particular offense. It's one where he's going to come in and say he's guilty, and so we're just going to be going into punishment on Tuesday, with us picking a jury on Monday, and then we're going to begin the guilt innocence phase on Tuesday. If he's pleading guilty, we're just going into punishment, and he knows that, then I'll make sure that I have all my punishment witnesses here ready on Tuesday.
All right. Mr. Phillips, do you, since you're saying on this case that you are guilty, do you intend to plead guilty and just go to the jury on punishment? Or do you want a full-blown trial?
Yeah.
You want to plead guilty before the jury?
Yeah. I don't need to be. I'm guilty. I had to be on him.
Well, do you want?
I'm going to work my way out of it. I'm stupid enough walking down the street with my pocket.
Well, Your Honor, before we go any further with that, I suppose the court will need to meet with him and go over the counsel waivers and all those things before he could do that, I think, without counsel. And I think I should absent myself from any of those matters and let that be handled between you and Mr. Dohoney and the defendant. And y'all let me know how that goes. But if we are going to handle it that way from a procedural standpoint, that's the extent of my inquiry. Is just for efficiency of court purposes on when I'd have witnesses present, since a number of them are from out of town. Most of them are here local.
Well, what I will do is, Mr. Phillips, I'm going to send you that waiver form. I'm going to go get lunch, have you have time to read that waiver form. I will then come back. You and I'll pull you up on the video, personally go over the waiver with you, make sure that's still what you want to do. I certainly would not advise it, but you're right. When you say you have the right to do it, you have the absolute right to represent yourself. And after I have done that, then I will get let Mr. Pratt know, send Mr. Dohoney a copy of the waiver. And if you decided that you want to withdraw, he's going to file the election for the jury to assess punishment. If you decide that you want to withdraw the portion where you've requested a jury trial as to guilt, innocence, plead guilty before the court, then the only thing the jury would have to decide would be punishment. But you're welcome to go to the jury on the plea as well. But you and I can talk about that only after you've completed your waiver of counsel. I can't talk to you about that before then. It's just something I want you to be thinking about. All right. I'll call you back probably around 1:30.
Oh, Colin, you walked in at a good part. It was the very end, but it was a good part. Oh man, guys, if you haven't seen Colin's channel yet, which I know that you all already have, please go and look. Hi, John. Whew, what a stream, guys. That was a stream, all right. Thank you so much for coming out today. It's 6:35. 3 hours until Fleischer starts. If the electricity works. Victoria, thank you so much for coming in. But no, you really should go watch the first one because it's really good. It's really good. Cloud, thank you so much. 8:30 p.m. Oh man. Today's my vacation. I mean, my weekend. Today starts my weekend. I did not want it to be 8:30 p.m. I want it to stay 6:35 a.m. for at least 5 more hours. See, that was very professional, was it, Cha? Oh man. Tell Melissa we said hi. All right, guys. Behave, first of all, and I'll talk to you soon. I'll have some good stuff for tomorrow. Rome, yes, thank you for translating. Good night, all you Aussies. Good day, everybody else who's not over way far. Thank you, Fozzie. Thank you, Lori. Bye, Sarah. Cloud. Shanghai. That's right. You're in Shanghai. Have a good night. Have a great night. You too, honey. Thanks, Rebecca. Discord. Hold on. I got to click this one. There we go. Legal. Have a good day. Yes, Cha, I'm going to try to find you in the gallery in Thurston. I'm going to show everyone.